almost there, Your Honors. Just a little parched.
Oh, no problem.
Don't want to get caught now from the argument. You ready, Your Honors?
Ready whenever you
Thank you
are.
so much.
And I guess maybe as a preliminary matter, let's talk about the suggestion of bankruptcy that we just received. That involves Mr. Edwards personally. Am I right on that?
That is correct, Your Honor. It's personal chapter 7.
So it had anything to do with this case?
Has nothing to do with this case, Your Honor, and in an abundance of caution and consultation with my bankruptcy law partner, what we did was we filed a notice both in the circuit court and then essentially the same notice with Your Honors with the circuit court notice attached explaining that we are no longer pursuing any 57105 sanctions against Mr. Edwards personally
Okay.
to avoid any issue with the automatic stay under the bankruptcy portions of the United States Code.
Do you agree, sir?
I agree that the stay doesn't stop this proceeding from going forward.
Okay, that's fine. Okay,
May it please the court, Your Honors, it's great to be in front of you live again. I think the last argument before you was via Zoom, so I appreciate being here. Thank you for your time. My name is David Luck. I represent the defendant appellant, Van Santlaw LLC, which is a Georgia LLC that, like the other defendant in this case, has no relevant connections to Florida. Your Honors, I would respectfully request 2 minutes for rebuttal.
okay.
Yes, sir.
You were here listening to everybody claim 4, now you want 2. All right,
In my experience, the longer you go on rebuttal, the more muddled your points get. So
all right,
I will stick with 2.
okay.
And Your Honors, what I'd like to do is start off with the low-hanging fruit. Number 1, there was a position throughout, and this was a position expressed for the first time on review. There was a position expressed in my colleague's answer brief that somehow we didn't present evidence here supporting our contentions that there was no personal jurisdiction, no subject matter jurisdiction, there was improper venue, and that there was a forum nonconvenience issue here. I want to clear that away and highlight that that is absolutely not true. I would refer Your Honors to a decision from this court in 2002, unanimous panel opinion authored by Judge Silverman, which claims counsel actually cites but doesn't provide the complete quotation. It's Mason versus Highlands County Board of County Commissioners. That's at 817 Southern 2nd, 922. And the relevant quotation appears on the second page of the opinion, and it is as follows. A finding that a party is entitled to recover attorney's fees under section 57105 must be based upon substantial competent evidence presented at the hearing on attorney's fees. Opposing counsel stops there. However, it's a disjunctive quote and it continues. Or otherwise before the court and in the record. To be clear, Your Honors, what we have here is as follows. We have a complaint that is filed on April 29th, 2021. 19th. That complaint crosses my desk on the Thursday immediately following that date, which I believe was the 22nd of April. The first communication I have in this case to opposing counsel occurs on April 27th of 2011. I write a letter to opposing counsel explaining that the aircraft is located in Georgia, that the operating agreement at issue here requires that it be located in Georgia, that the defendants here are Georgia entities, and that if this is not dismissed, we will not only be moving to dismiss.
To the point of the evidence that you discussed, though, how do we know that the aircraft was always in Georgia? There's a testimony to that effect. You've made that assertion in the trial court and in your briefing here, but wouldn't that be an issue that could be some simple testimony or flight log, something like that, presented at the trial court?
Sure, there was testimony, Your Honor, in the form of uncontradicted affidavits. My initial communications.
All these facts are interesting, but that's not the issue here today.
Correct.
The issue here today is Judge Duradka denied your motion for fees with a simple denial with making no findings or elaboration. And you've taken the position that that violates the law and we should send it back for basically him to make some findings. Now, there's a lot of cases that talk about the failure to make findings in a grant, tons of them.
Yes, Your Honor.
I'm not interested in those cases. They don't mean
Understood.
anything to me. I'm interested in the ones that basically find in a denial, you got to make these findings. And before you touch on that, this is a common theme throughout civil practice. A grant requires findings, a denial doesn't. So show me why this is different, show me what you got.
Sure. So, Your Honor, the reason it's different, and this also goes back to Judge Stargill's point, we had uncontradicted evidence. We had not only a 57105 motion, which had multiple exhibits on which I relied at the hearing. We also had a motion to dismiss that was filed 1 week after the 57105 motion and was consistent with my initial communications to opposing counsel, where I said motions to dismiss for lack of personal jurisdiction and forum nonconvenience require affidavits.
We
I will be
don't like
providing.
Judge Duratka's ruling, I'm sure of that.
No, I understand.
But you haven't raised that as an issue in this case. You've raised one issue. He gave us a simple denial. He's supposed to have made findings.
Correct, Your Honor, I'm getting to that point, so
Okay.
with your indulgence. I'm mentioning this point about evidence because the bulk of opposing counsel's answer brief was directed at the lack of evidence. There is significant uncontradicted evidence
Well,
here.
both of you spent a lot of time in your briefs talking about things that were
Sure.
unnecessary.
Well,
You've
I-
spent a whole bunch of time talking about who's right and who's wrong. I just want to know about the simple
Sure.
denial. That's the issue.
And I'm gonna answer your question right now, Your Honor.
If he issued a simple denial without findings, and he should have, it goes back.
Sure, Your Honor. So here's why findings were required here. And to be clear, we're not arguing that the written order necessarily had to include findings. Our argument is that when the judge, and he expressed absolutely no reasoning at the November 1st hearing, and I was the only one who presented any evidence at that hearing. He provided no reasoning there, and then his order, which is at record 296, simply says that the said motion is denied. It provides absolutely no reasoning. This court, I believe this court's most recent 57105 decision is Suarez versus Bank of New York Mellon Trust. In that case, on the bank's 57105 subsection 1 motion, this court was careful to point out that while there were no findings in the court's written order, on the record at the hearing, the trial court had provided insufficient findings.
But the court didn't say there had to be findings. The court just referenced that.
Your Honor, your review mechanism regarding 57105 depends upon an understanding of what the circuit court's basis was, because the Florida Supreme Court in the Boca Berger case, Justice Cantero, former Justice Cantero, said that you cannot come up with fact finding for the first time on review on a 57105 motion, nor can opposing counsel.
Does the 57105, it's sub 1 you're going traveling under?
1 and 2, Your Honor.
Yeah, 1 and 2. Does either of the text of those statutes say specifically that in the denial of a motion for fees, you must make findings?
They do not, Your Honor.
But they say the converse.
They do, Your Honor, but here's the point.
So you want me to be an activist judge and supply that language?
Absolutely not. Here's the point, Your Honor. Your review ordinarily is for abuse of discretion on a 57105 motion. If there are no oral findings and there are no written findings, how on earth are you supposed to determine whether the trial court exercised appropriate discretion in denying a 57105 motion when the legislature has clearly stated in the statute that these fees shall be awarded as a sanction if the statutory criteria are satisfied? There was no evidence presented below that we failed to satisfy the statutory criteria. Consistent with this, the 4th District, I believe last month on August 17th, decided a case called Dental Law Firm versus People's Choice Public Adjusters. At page 11 of the Lexis version of that opinion, which we provided to supplemental authority on September 11th, the court explains that there was a summary conclusion that the statutory criteria was not satisfied. It then reviewed that summary denial of the 57105 motion and held that the facts that were actually presented at the evidentiary hearing showed that the 57105 motion should have been granted. We have the same situation here, combined with the fact that this judge gave no oral findings and gave no written findings. I would also point to the Sanssouci 1-paragraph decision in the 3rd District, which is opposing counsel's entire case. Sanssouci, and I believe that was issued in March of 2021, it was 317 Southern 3rd 243. In that opinion, the 3rd District explains that there was a determination made by the trial court regarding lack of satisfaction of the statutory criteria. And then the court said that they were only writing to address the sufficiency of the order, referring to the written order. Sans Souci does not hold that a trial judge can provide carte blanche insulation from 57-105 abuse of discretion review by standing mute during the hearing and then issuing an order that simply says denied. And your honors, going to the case law that we referenced regarding even situations where there isn't a statutory predicate requiring written findings, I would point your honors first to Rivero versus Rivero, which we cited in our briefing. 44 Southern 3rd, 1263, First District Court of Appeal 2010. In that case, it was a marital dissolution action, and the issue was the trial court there had found that the husband should have access to the wife's medical records, and the wife was required to execute HIPAA authorizations such that the former husband would have access to her medical records to determine whether she had a drug dependency problem. In that case, the First District Court of Appeal said that that ruling in the order could not stand because the trial court had not given any findings supporting it. And the quotation from that case is that in any case in which the trial court's failure to provide findings impedes or interferes with the appellate court's ability to review for abuse of discretion, reversal is
So
necessary.
you would have us adopt rule in the second across the board. Every 57-105 must have written findings and then a conclusion, whether it's a grant or a denial.
Absolutely not, Your Honor. Our position is that oral findings on the record at the hearing, which by the way is what Judge Arises did in Sans Souci,
Okay,
or written
so
findings.
either to announce there and then deny it, but failure to do that, even then a denial, where there's, the judge looks at it and says, this doesn't meet the standard, denied, that's a reversal.
Correct, Your Honor. And this goes back to Your Honor's point, Judge Morris, about we have one issue here and you don't necessarily want to get into the merits. I cannot argue to you whether Judge Hiroka had any legitimate reason whatsoever to deny this. I think that I can, but I can't do so definitively because there are no findings, oral or written. How can I argue to you, Your Honors, that he abused his discretion, or how can opposing counsel, more importantly, argue that the trial court exercised appropriate discretion when they never filed any evidence or written opposition to our motion? They had an unsworn argument from their trial counsel at the hearing, and then for the first time on appeal, they're trying to argue what they think Judge Hiroka might have been thinking based upon misstatements of the law and misstatements of the fact. We are not asking, Your Honors, to rule consistent with Bokeberg. We're not asking you to substitute your judgment for the trial court. I'm not asking you to rule that our 57-105 motion needs to be granted. What I'm requesting from Your Honor is that when we are the only ones who came forward with, number one, a motion for sanctions that was supported by multiple exhibits, and number two, a corresponding motion to dismiss for lack of jurisdiction, lack of venue, and forum nonconvenience, and the opposing counsel comes up with nothing, and that goes in front of a trial judge. The trial judge can't say at the end of the hearing, I'll think about this and get back to you, and then issue an order saying denied with absolutely no reasoning. The legislature made clear, and this court explained this in Suarez as well, 57-105 sanctions regarding any claim or defense or even positions asserted on appeal can result in sanctions if they're not supported by facts or law. And if the statutory criteria are satisfied, imposition of those fees is mandatory. If Your Honors allow a judge, even a judge who might have good intentions, to deny a 57-105 motion without saying anything on the record and without saying anything in a written order, you cannot review that ruling for an abuse of discretion. I submit that it's impossible. Your Honors, an additional point I want to make here goes to a little bit of the merits, but I'll keep it brief. So opposing counsel's position expressed for the first time on appeal is that even though there wasn't evidence of this and it was just argument of his trial counsel, there was a good faith reason for opposing counsel, despite our unopposed motion to dismiss and our unopposed motion for sanctions, not to dismiss an action that involved Georgia entities, a Georgia-based aircraft, a Delaware LLC, and 2 Georgia entities, and a principal of their former client who resided in Georgia, as indicated by the fact he verified the complaint in Fulton County, Georgia. All of that, they say, oh, well, we had difficulty communicating with our client. This was hard. We didn't hear from him. That's why we didn't say anything to opposing counsel for 6 months, and we never opposed any of their motion practice. Your Honors, Mark W. Richard, PA versus Nature Sleep. It's a 2018 decision from the 4th District Court of Appeal. It's at 261 Southern 3rd, 567. The relevant portion and analysis of the opinion appears at pages 570 through 571. And there, the opponent of the 57-105 motion took the position that it could not withdraw a non-meritorious filing because his client was out of the country and he couldn't reach his client. The 4th District held, you as counsel, when you are given information, you have a non-meritorious filing, have an independent obligation to review that position, and even without permission of your client, if there is no basis to support it, you have an independent obligation to withdraw the filing. And
But my recollection is that counsel said he had relied on certain representations by his client. So how could he independently investigate them if he couldn't even get a hold of his client to ask him about them?
so, Your Honor, that was completely unsworn statements, and
But he's an officer of the court. I mean, that's the representation he's making.
it is, Your Honor. However, as an officer of the court, he also lied during the hearing and said that we never set our motion to dismiss for hearing when we absolutely had. The bulk of what Mr. Anthony said during the hearing is demonstrably false. So in terms of a credibility determination, which the trial court is going to have to make in the first instance, his representations to the court were severely lacking in integrity and honesty. The bulk of what he said was not true. So how can we trust his representation regarding what his client told him? When his client never testified to that, they never filed any evidence, and he simply showed up at a hearing and said for the first time, here's something my client told me.
But
The
to
fact-
that point, if you started seeing this, why didn't you ask the court to continue so you could have a longer time frame for more evidence you're hearing, or put some testimony on at that point to prove that what he was saying was demonstrably false?
Because we didn't need to, Your Honor. We were the only ones who filed evidence before the hearing. I had 2 uncontradicted affidavits from my client. I had the operating agreement. I had the relevant Georgia Secretary of State Division of Corporations records. I had the Delaware LLC records for RK 324, which is the entity that
There
they
were
formed
statements
to
being made
operate.
about the residence, the location of the plane, other things, and now you're saying other things that he was saying was false. You really haven't answered my question. Why? I mean, you're saying you just have to believe us because it was all false. And I put this forward, they rebut it, and you choose to just rely on what you put forward, which was unsworn testimony at the hearing.
Well, Your Honor, I disagree with the premise of your question. They didn't rebut anything. He was not under oath. He didn't provide any evidence. He simply said something as an attorney in court. In contrast, I filed sworn affidavits. I filed authenticated corporate documentation. My clients testified in their affidavits the aircraft was located in Georgia, that they had never agreed to move the aircraft, that the operating agreement required that the aircraft be located in Georgia, that they reside in Georgia, that they are Georgia entities, and that Mr. Edwards resides in Georgia as well. And consistent with that fact, Mr. Edwards verified the complaint from Georgia. The operating agreement lists Mr. Edwards' address as in Georgia. I had my evidence. They had nothing. Saying that I failed to rebut them when they had a lawyer come in who failed to file any written response or any evidence to my motions that had been pending for 6 months, pardon me, Your Honor, but I think is a dereliction of their duty. They had no evidence. And this judge, in response to that, said at the conclusion of the hearing, I'll get back to you on this, and then he issued an order that said denied. There's no basis for this court to determine whether he appropriately exercised his discretion, and there was no need for me to ask for additional evidentiary hearing when I was the only one who properly prepared for the hearing. I got 6 months of no response from their side. I got lies upon lies at that evidentiary hearing. They didn't submit any counter affidavits. They didn't file a single document. They simply stood up at a hearing and said things that were false, including that we never set our motions for hearing, and including that they didn't plead in the complaint that Mr. Edwards was an alter ego of Air Isaac LLC.
I don't want to take your rhythm away, but you're at 18.
I understand, Your Honor. Respectfully, we're not asking for Your Honors to decide this 57-105 issue today. All we're asking for is that a judge regarding a mandatory fee sanction imposed by the legislature provide either an oral indication as to the grounds or a written indication. There was nothing of the sort here, and because of that, your honors cannot review for abuse of discretion. We respectfully request that you reverse and remand for an explanation of the court's reasoning. Thank you for your time, your honors.
You're gonna have a minute and a half when you come back.
Understood, your honor. Thank you.
We don't know just to get up. Good morning, may it please the court. I'm Scott Stevens, Evelyn Partners of Counsel. And I'm here to ask the court to affirm the decision that Judge Taraka correctly made. You had the basis in the statute, the case law allows him to make a determination based on what's before him. The only thing that was sworn before the judge was properly could have been considered by the judge was the verified complaint that said the plane was in I think it was in St. Petersburg, and said that it belonged in Florida, and sworn by the client. The attorney relied on it. So the basis for denying the motion for sanctions is plenty clear in the record, and to superimpose a new requirement now that there be written findings or oral findings, either one, in denying motions for sanctions would burden the trial courts quite a bit, I think, for no good reason.
So anytime a court denies a motion for sanctions with a simple denial and no findings, it eviscerates basically any meaningful appellate review. Do you agree?
I don't agree, sir. I think that some of the cases, in the Suarez case is one that illustrates the point. You can look at the record and you can see if the record required the trial judge to go ahead and apply those sanctions. And the court has never been shy about sending a case back to a trial judge who they think needs to either explain their reasoning better or who needs to follow the plain text of the statute and apply sanctions in a case where it's clearly called for, like it was in the Suarez case. So you do in fact have the ability to review an order that's unelaborated. It's just that the basis for the order, if it didn't appear in the record, it would be subject to potential reversal of the order. And that's why I think you saw so much attention to the merits and to what the basis of the record was in both of our briefs.
I understand it better now, and actually that's helpful. But at the time, I was thinking, this is the narrow issue. Why are we talking about all this? But you all made it clear that that was helpful to understand.
The only other point I want to make is I want to respond to the suggestion that Mr. Anthony was dishonest in the trial court. I don't think that's correct at all. There is a difference between what Mr. Anthony said, and I can see how counsel might have drawn that conclusion. He said he didn't call up the motion to dismiss. The defendants called up the motion to dismiss and the motion for sanctions together. They insisted that they be together in an evidentiary proceeding. As a result, it took 8 months or so to get in to see Judge Taraka, and he couldn't do it on a 15-minute docket like he usually would handle motions to dismiss. So that's what he was referring to. Obviously, the case had been called up for hearing. They were in the judge's courtroom. He's not trying to tell the judge he never got called up. And so that was just a misunderstanding. And I want to make it clear that it's really not appropriate, I think, to come away with the conclusion that he was trying to deliberately be deceptive. And with that, Your Honor, I'll yield back all my time unless there's questions.
Okay. Thank you, sir.
May it please the court again, David Luck, and I'll keep this brief, your honors. I just want to go through the points that opposing counsel just mentioned. He says there's a basis in the record for denial. Let's recap what they submitted before this hearing, which was 6 months after the relevant motion practice. They filed no written opposition. They filed no evidence. They filed no sworn testimony via an affidavit or declaration, and they had a lawyer show up, not under oath, when there's case law, including from this court, saying that arguments of counsel not made under oath are not evidence. They have no evidence. Here's the evidence in this case. From our 57-105 motion, which was properly served on May 4th, 2021, and then filed after extra days were given on the 21-day safe harbor on May 27th of 2021, we have Exhibit A, the operating agreement. Exhibit B, the verified complaint, which their client verified from Georgia because that's where he lived. Exhibit C, all of the defendants' relevant Georgia
If you don't mind,
records.
you've already gone through this, and I'm going to ask you a question I think
Sure,
is
Your
very
Honor.
important. Can we reverse this based on the simple denial?
Your Honor,
In other words, not basically saying, go back and make findings. Can we reverse it on the record we have?
I disagree with opposing counsel. I'm going to adhere to my reading. I would like for you to do that, but Justice Cantero respectfully in Boca Berger explained that an appellate court, when a trial court on a 57-105 motion makes no factual findings, you cannot make those findings for the first time on review. So talking about earlier, Your Honor, I believe referenced whether I'm asking you to be an activist court, I'm asking for the opposite. I'm asking for proper deference to the trial court's fact-finding function, so it, in the first instance, can give reasoning, whether oral or written, when there was none. Finishing up, Your Honor.
You're way over time.
All right.
So be brief, please.
Yes, Your Honor, very brief. Said the complaint is the only sworn evidence. That's wrong. Multiple exhibits that we filed. Finally, Suarez, he relies on Suarez. Suarez had findings. This court carefully explained there were no written findings, but there were oral findings. They provided you no compelling arguments, Your Honor. This court below needs to provide reasoning. Thank you, Your Honors.
Thank you both very much. Have a good day, gentlemen.
Thank you as well, Your Honor.
Thank you for your time. Okay, we're gonna take a 10-minute break. We'll call the next case.
All rise.